Oh, okay.
I see a Shira Pitts in the waiting room. Pitts. I don't have that on my docket.
Oh, jeez.
Some files. I'm gonna get them.
Jeez, what?
It's from the civil. Shira Pitts.
Yes.
What's your, okay, is your last name formally Craddock?
Yes.
Okay. Okay, we're on the record in the matter of the people of the state of Michigan versus Anthony Shearer in file number 19-04185 FY. Appearance for the record.
Sheriff Brodowitz on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Anthony Shearer.
Okay, Mr. Shearer, today was the date that was set for a hearing on a probation violation, to which she was previously arraigned. Let's see. Violation alleging that you failed to provide proof of completion of outpatient substance abuse program as ordered by the court. Are we having a hearing on this, Mr. Lee?
No, we are not, Your Honor.
Okay, so Mr. Shearer wishes to plead guilty.
That is correct.
Yes.
Okay, Mr. Shearer, please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Thank you. You can put your hand down. Okay, so you have the right in this matter to have a contested hearing. You were advised of the rights relative to the probation violation process at your arraignment on that violation. You wish to waive your rights and enter
Yes, Your
a
Honor.
plea today? Okay. Anybody threatening you to waive your right and plead guilty to the violations?
No, Your Honor.
Okay, again, and the violations also include a failure to report to probation officer back on April 26th and May 24th, 2023, as well as a violation of failing to provide proof of completion of outpatient. That's correct. You want to plead guilty to all of those violations, correct?
Correct, Your Honor.
Okay, anybody making any promises to you in exchange for you pleading guilty?
No, Your Honor.
Okay. As to the violations that I just read, how do you plead?
Guilty, Your Honor.
Factual basis, counsel?
Thank you, Your Honor. Mr. Shearer, were you placed on probation in case number 19-04185-FY?
Yes, Your Honor. Yes.
Okay. And in April and May of 2023, you were still on probation, correct?
Correct.
And as part of your probation, you were ordered to report to your probation officer, correct?
Correct.
And did you report to your probation officer on April 26, 2023 and or May 24th, 2023?
And
Okay. And you were also ordered to provide proof of completion of outpatient substance abuse, correct?
yes,
And you did not complete an outpatient program and therefore were not able to provide proof, correct?
correct.
Thank you. No further questions, Your Honor.
Any questions, Mr. Brodowitz?
Nothing from the people, Your Honor.
I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. I also find the factual basis to be sufficient to support entry of the plea. The recommendation that I have here from probation is to terminate your probation status and impose a jail sentence. It says defendant has absconded from probation again. This would not have been his first time from absconding. Therefore, Mr. Lee, you can make allocution.
Thank you, Your Honor. Your Honor, Mr. Shearer is a father, a son, and a husband. And if I could most succinctly summarize what I have received from him in this process, is that he's scared. Mr. Shearer suffers from alcoholism. He lost his ability to live in his home due to alcoholism. He has failed in his probation due to his alcoholism. He desperately desires treatment, although he doesn't trust himself to complete an outpatient program. He comes before the court today, asking the court to consider him for inpatient rehab to help him save his life. He doesn't want his wife and kids to see him die. He doesn't want his father to see him die. He would like to get out and spend some time with his dad before it's too late. And throws himself on the mercy of the court and asks the court to consider some type of inpatient rehab for him.
Yeah, I'm getting a little bit of feedback, I think, from the jail, but I think I gathered the context of your allocution. The concern that I have here is that this was the second time of the court giving Mr. Shearer an opportunity to take control of the addiction from the outside on his own in outpatient services. We've given him ample opportunity to participate in outpatient treatment and services, and all he needed to do was provide evidence of that. He's had multiple violations, but he's absconded from probation more than once. And it also should be clarified that he was remanded on this and other bench warrants. And while in the custody, he was suffering from a medical emergency due to withdrawals from alcoholism. And so I made a decision to amend his bond so that he could be hospitalized for treatment. While in the hospital, he attempted to escape when he needed treatment. He is not in a position to take his treatment into his own hands. I have zero choice when it comes to how I can move forward with this. I cannot release him into the public. If I release him into the public, the likelihood that he would kill himself with alcohol is greater than that which he would if he were stay in the custody and be remanded directly into treatment. And that is exactly what we're going to do. He's not getting the help he needs on his own because he's not in a position to navigate that. And that's how detrimental his alcoholism is. And so with that being stated, he will be sentenced to 120 days Ingham County Jail, credit time served. He will be only released into the custody of inpatient treatment only. He will not get any earned early release, nor can he get GPS tether. Once his treatment is completed, the remaining balance of his days can be served on probation, but not until he has completed inpatient treatment. Do you have any questions, Mr. Shearer?
I mean, the detox, my alcoholism came back and forth worse. I was actually having in the tree. You know, I mean, I'm good. I'm trying to keep this something to save my life. Yeah, I mean, this is word that I never understood the words cooking, bathing, and powerful. You know, from there until now. I mean, I'm ready to do what I have to do.
Okay,
So, I
that's
mean,
wonderful, because you'll be doing it at inpatient treatment. You're not, we've given you more than 2 chances. You have multiple violations and more than 1 absconsion from probation. And you've even tried to escape the custody when you were supposed to be getting treatment at a hospital. There's no option. This is not even a negotiation. And I hope that you are ready to do what it takes to get to your recovery, because that's the only way your family is going to see you healthy. Your ability to navigate this on your own is, you've already tried it multiple times and you've not been successful, and you've left me with no other choice. Any additional matters for the record, counsel?
I got one more question, Aaron.
Yes, sir.
My other court dates for the next week. I mean, is that gonna hold me up when we go to treatment?
Your court dates for other files will be taken care of as necessary. Even if you're in treatment, they have the ability to get you on Zoom for court dates. Okay, sir?
Okay, Your Honor.
Thank you. Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
One last question.
Thank you, Your Honor.
Thank you. You're all set.
Last question. So I'm basically down.
I'm sorry?
I'm basically set to go to like, as soon as the leg opens up, I'll be able to start attending my treatment. I'm just so sick of this life. I mean, it's been 6 years. I can't feel my legs and my feet. I mean, I can't do this.
I understand. I'm not sure what your question is, though. Could you repeat it for me?
Am I okay? Like, am I like as soon as the leg opens, am I set to go to treatment?
Unless you have something pending that's not before me, I can't speak to that. And there's no cases that you have pending before me that will prevent you from being released immediately to a bed that becomes available. Okay. Okay.
Thank you for this chance. I promise I won't let you down.
Okay. I really hope you won't. You look, the last time I saw you after the last absconsion, you looked far better than you do right now. And this alcoholism has taken a huge toll on you. And I think you already know where it's leading.
I'm gonna die.
Yeah.
I can't get my legs all the way to my knees. I mean, I got neuropathy. I mean, it's going bad. I couldn't go an hour without taking a drink.
Right. So we have to get you the help that you need. So you're gonna need to move in the jail because it didn't pick up any motion, so the light cut off. Okay, there you go. Yeah, it's gonna be a long road to recovery, but again, if you say you're ready, if you have the mindset to do it, you can be successful, sir.
I have to do it. It's not a want to, it's that I need to. I'd rather die real soon.
Okay, well, good luck to you. And next time I see you, it hopefully won't be under these circumstances, and hopefully you will be healthy. Thank you.
Have a good day.
You too.
Bye-bye.
Bye. Is Mr. Salazar present, or Dominic Salazar present?
He is, Judge. He's here in person in the courtroom. He's going to be standing next to Mr. Lee.
She doesn't know.
On the record in the matter of the people of the city of Lansing versus Dominic Salazar, file number is 23-000201 OD, council appearance.
Assistant Public Defender John Lee on behalf of Dominic Salazar.
Okay, Mr. Salazar, today is the date that's set for an arraignment on a probation violation. I have a request and summons for probation violation here, and it alleges that you violated the terms of your probation by committing the following violations. States that you allegedly tested positive on August 25th, 2023 at EverHealth for alcohol with a result of ETG greater than 25,000 nanograms ETS and greater than 25,000 nanograms and for cocaine in the amount of 355 nanograms. And so you have the right to have a contested hearing, and you have the right to be represented by an attorney at that hearing. If you cannot afford to hire an attorney, court-appointed counsel can be appointed to represent you at the expense of the public. If you're found to be in violation of your probation conditions, your probation status can be terminated. You can be sentenced to a term of jail time, or you could have other sanctions and oversight implemented into your probation status. Your probation also can be extended in order to get whatever treatment or programming is necessary completed. Do you understand that, sir?
Yes, Your Honor.
Are you requesting court-appointed counsel to represent you for the violation?
Yes, Your Honor.
Okay. So we'll enter a plea of not guilty at this time as to the violation. We'll set this matter for hearing, and then if you have not already, Mr. Lee can meet with you and do an intake, okay?
Yes, thank you.
October 3rd at 1:15.
Okay, so your hearing will be October 3rd at 1:15. Do you have any questions for the court today?
No, Your Honor, not at the moment.
Okay, and in the interim, you'll continue to meet with your probation officer, and then we will see you on October 3rd.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you.
Hello,
What's your name?
Brenda Cowell.
Okay, Ms. Cowles, you need to dial in using the instructions that you were given for video. I do not do telephone conferences.
Okay, I'll try that again, Your Honor.
Okay, thank you.
Thank you.
No problem. Mr. Runyon is here, and he's on the matter with Miss Pitts, also known as Miss Craddock. Let's see. I don't have anything on file number 09-03979.
Good afternoon, Your Honor. Timothy Rennie on behalf of the plaintiff.
I was not calling the case. I was talking, I was talking to my staff. They haven't sent me the file yet.
Okay.
Okay. On the record, in the matter of Reliable Auto Finance versus Rebecca DeJager, I believe it's how you pronounce it, and file number 09-03979. Anybody here on behalf of them?
Yeah. Right up.
Oh, Your Honor.
What's your name?
Rebecca Dieger Geller.
Okay. Anybody here on behalf of Reliable Auto Finance? Okay, well, today was the date set for a hearing. And it was a hearing for objection to periodic garnishments. I do have a request for an extension here in my file.
That was because I was waiting on documentation, Your Honor.
Okay, have you received the documentation that you were requesting?
I have, but it's not the full documentation that I requested. On top of, they made me pay for it at the post office in order to receive it.
Okay, well, if they failed to appear, nor did they send an attorney to represent them for this purpose. So I'm going to grant your motion by default.
Thank you, Your Honor.
You're welcome. You're all set.
Thank you.
Is Nicholas Trevino present?
No, Judge, we got a hearing cancellation on that.
Okay, sounds good. Brenda Cowles is going to log back in, I believe. And then,
Yes, but we also got a cancellation on that too, Judge.
oh, okay, well, nobody gave me an updated. Otherwise, I would have told her that when she logged in. Let's see.
There was a cancellation on Cowles.
Mr. Bigelow?
That's what JIS says that Sybil entered.
I missed that statement, Your Honor.
Correct. He's saying that our judicial information system indicates that the civil department entered a cancellation. What date did they do that, Mr. Bigelow?
Actually, you know what? No, I actually have the wrong case number and entered. I was still looking at Trevino's. Disregard.
Yeah, I've got, my file shows personal service August 21st of the subpoena.
Okay, well, she just logged in and she was gonna log in with her video, so she should be attempting to do that at this point.
And
What about,
on Trevino, I show service as well. Did Nick say that, or Nicholas say that that file was pulled by civil? Because I'm showing service on the subpoena on Trevino as well. Nicholas Trevino?
I see that in JIS as well. It's August 16th.
Yes, sir.
Mr. Trevino has not checked in. He's not here.
Okay. I'll do what I can with Miss Cowles if she's available and when the court is ready.
okay, sounds good. And then we have Cowles, and then you had one more, I believe. Julie Mishner.
Believe,
And two more, Gina Smith Kirkling. Are either of them present?
I don't believe we had service on either of those files because my it's not on my list today, so I'm guessing that they neither received service.
Did we get service on those, Mr. Bigelow? Or I missed
No,
that?
and Gail just sent a message 30 seconds ago saying that those two were canceled, that they received the notices for them.
Correct.
There's no service.
No service on those two. Okay, sounds good. So we'll wait and see if Miss Cowles appears. And let's see. I believe I see Mr. Lum. Mr. Lum is present, and then Desiree Henry. Is she in the courtroom?
She is, Judge.
Okay, on the record, in the matter of Edgewood Villas versus Desiree Henry, file number 22-03865 LT. Appearance, please.
Good afternoon, Your Honor. Brian Lum on behalf of the plaintiff. I did speak with the civil department yesterday, and they had told me that this case had been taken off the docket, and so I apologize for my address today, Your Honor.
No worries. Let's see, and then I see Miss Henry in the courtroom. You can hear me, Miss Henry?
Yeah.
Is that a yes?
Yes.
Okay, today was the date that I reset this matter so that you can provide the court with some additional documents. However, once you left after the last court date, we did receive a forwarded email to the Judge Simmons courtroom email, essentially corroborating the statements that you made that they refused to cooperate and take your payments. There was an email that we received from Miss Henry. It was from Natasha Boykins, who's the leasing manager, who advised Mr. McDonald that they were no longer taking her payments as she was already evited, but I believe they meant evicted, and that her last day in the unit was going to be August 7th. This was an email that they sent to her on August 4th. Ms. Henry represented to the court that she was working with agencies or attempting to get some assistance so that her rent could be paid. This is a eviction for non-payment of rent. This was not a termination of tenancy. After the court had their hearing, which extended over the course of multiple days and gave her the abated amount, she had time to pay that or vacate.
I have not seen that email, Your Honor.
Okay, well, your client forward you a copy of that email. It's from Natasha Boykins. She's the leasing manager. She's never been brought to the court. The person that's been coming to the court never seems to have the information relative to receiving monies or any direct knowledge as to what's going on as it related to the things that were being alleged by Ms. Henry, which was troublesome in the first place. But nonetheless, this name, Natasha Boykins, came up multiple times from Ms. Henry. I did request her to bring some information, but after seeing that she was working with the City of Lansing's Housing Ombudsman to try to connect with agencies, I find it problematic that your client would put her in a position where she could not avail herself of those resources.
Like I said, Your Honor, I haven't seen that email. I was not aware of that.
Okay.
I have worked with Mr. McDonald in the past with tenants of this property, so I don't know why.
Okay. Ms. Henry, have you had any further communication with the Housing Ombudsman or with any other agencies to try to get the past due rent amount?
I got in touch with Ms. Joe McDonald. She had just sent me a voicemail saying that what they could pay and who we needed to send the email to. And then I got in touch with the Eviction House, and the Eviction House basically reiterated with my apartment complex, and they basically stated to them now that they'll take the payment. They're trying to do a promissory note, she stated to me in my text message that she just sent me yesterday.
Okay. Is Mr. Bigelow in the courtroom?
Yes.
Do you still have or is that email that came from Ms. Henry back on August 24th still in your possession? If so, if you could you forward that to Mr. Lum?
Say from August 24th?
Correct, that you forwarded it to me. If not, I can, if you can get that to Mr. Lum, he can have that email, because based on that email and other representations that Ms. Henry made at the time of her last hearing, I am going to grant her motion to stop the eviction, and I am going to grant her time to so that she can work through the process, since your client was not cooperative with her getting the paperwork signed and completed so that she could get the past due rent paid. Ms. Henry, you should make contact with Mr. McDonald and House, whoever you were working with, so that that paperwork can be completed. If you come into any more hindrances from the plaintiff's office, your leasing agent office, you need to come into the court immediately to file a motion so that we can get a hearing date for that, okay?
Sounds great.
I'm gonna go at this time and reset this out for 30 days for a status conference to make sure Ms. Henry has done what she was supposed to do and all the past due rent has been taken care of, or at least there's been a promise to pay from one of those agencies provided to Edgewood Villas. Can I have a control date for that status?
Hello.
One moment, Ms. Cowles.
Yes, Your Honor.
We can do October 18 at 8:30.
Okay, we'll set that for a status conference, October 18th at 1:30. Do you have any questions for the court today, Ms. Henry?
No, I don't. I'm just trying to figure out, like, if they gonna accept it this time, because like I said, she sent me the text message yesterday saying that they was gonna promise to pay, but they're not doing anything else. They haven't sent her nothing else since she's been asking. for
They
stuff.
haven't sent her nothing else.
The apartment complex.
The leasing off, that for some reason, they were under the impression that you were already evicted. You had a date based on our last, or not the last, the hearing before last. There was an amount that you were told you needed to pay, and you got a date to pay that by or vacate. And it sounded like, based on that email, at least, you were making efforts to get that taken care of, but they would not cooperate. So they tied up that process.
Joe McDonald.
I recognize that, but I seen your email. He was acting on your behalf though, and so they wouldn't cooperate. And so because of that, I am granting your eviction to stop, your request to stop the eviction so that you can have time to work through that process and get the assistance to pay the past due rent and move forward. I'm only giving you 30 days to do that. Do you understand that?
Yes, ma'am.
You should be continuously paying your other rents up until that point. And then we will address any hindrances if necessary, if you file a motion or you come before the court because they haven't been cooperative. But it's your responsibility to make sure that paperwork is taken care of. It's not Mr. McDonald's responsibility. He's assisting you. Do you understand that?
Right.
Okay. Okay. Any additional matters for the record, counsel?
Your Honor, I just wanted to confirm the time on the October 18th. Did you
I
say?
believe, was it 1:30, Ms. Nash?
No, it was 8:30.
Oh, 8:30 in the morning.
Thank you, Your Honor.
Thank you. You're all set, Ms. Henry. Thank you, Mr. Lum. Is Mr. Smith in the room with Ms. Cowles? Is that what happened?
Yeah, yes.
Let's see. I don't have, I don't see at least. File number 21-01562. Mr. Bigelow?
He just went to go scan it to you.
Okay. Okay, on the record, in the matter of Hamilton Road LTD versus Claude Miller, file number is 23-01344.
You have to be quiet. We're in the record.
Council appearance, please.
Good afternoon, Your Honor. Gene Turnwald on behalf of Hamilton Road Limited. Good afternoon, Your Honor. John was here, one of the defendants, which are the occupants of the
You
property.
come up to the table.
Okay, who's in the courtroom?
Yeah, Betty Miller.
Betty Miller, okay. And Ms. Miller, your attorney is Mr. Fair? Is that a yes?
Yes.
Okay, and who is the gentleman with you?
A friend of mine.
Oh, okay, sounds,
I live in the home.
Yeah.
Daryl Davis.
okay, sounds good. Okay, so they say was a date set for a continuation of a motion for escrow. I believe there was another motion, but I don't. There was a motion for order for escrow. Was there a motion to lift stay as well?
Yes, Your Honor.
Okay. Okay, and I requested for you to have your clients appear largely because I had heard multiple times from plaintiff's counsel or express a concern that you were not representing anyone that was connected to this actual property, if I am categorizing the concern correctly, Mr. Turnwall. If not, please correct me.
You are. My office received a phone call from Ms. Miller saying she hadn't signed certain documents and didn't understand what was going on. Just recently from the Court of Appeals, my office again has received a deficiency notice from the Court of Appeals saying Ms. Miller hasn't signed those documents as well.
Okay. What are those documents? Are they engagement documents or?
The actual appeal itself.
Oh, okay.
And the case will be dismissed now unless she signs it.
Mr. Fair, are you working with your client to get that taken care of or?
Well, the short answer to your question is yes, Your Honor. And that's not my understanding of the Michigan Court of Appeals concerns. But having said that, whatever the concerns are, we're within the 21 days and they will be taken care of within the 21 days, and the case is still pending before the Michigan Court of Appeals.
Okay. Okay, so addressing the motion to lift the stay, it sounds like this matter is still pending before another court. Accurate, or am I incorrect?
That's correct, Your Honor.
Your Honor, there's a big jump the defendants have made and ignored. The case has been dismissed in the circuit court, the trial court. To get a stay now requires an order from the trial court, which is the circuit court, which they have not applied for, and or post a bond. Initially required to post a bond in the Court of Appeals and get an order staying these district court proceedings. They have not done either. We're asking for possession only. This is no determination of ownership. If they want to proceed with this Court of Appeals case when they never even showed up to argue the trial court case, have at it. But it's my position, it's my client's position. This is entirely about delay. And I see Ms. Miller in a courtroom here today, but in the Court of Appeals case, in the circuit court case, she lists your address as somewhere different, that she's not an occupant of 2518 Pattengill. In fact, on those pleadings, she lists your address as on Ivan Drive, apartment 113 in Lansing. So she's not even an occupant of the address. Yet we were asking the court to stay the proceedings of a place she's not occupying. And we're asking for possession only. There's no circuit court order. There's no Court of Appeals order. The circuit court case has been determined and summarily dismissed.
Who's possessing this property, Ms. Miller?
Well, my husband, but they've been staying in it. I can't afford to rent it.
You're not possessing the property?
Yeah, I want to take the property.
No, that's
but
not what I asked you. Do you live in the property?
No.
Okay. Who is they? You said they are staying in it. Who's they?
Me and my wife live in the property, Your Honor.
What-
Daryl Davis and Mary Davis.
Daryl Davis and Mary Davis. Who do you pay rent to, Mr. Davis?
Well, we were paying rent to Claude Miller, and he passed, and then they were trying to refinance the house or to sell the home, from my understanding. I did about $10,000 worth of work, so we offset that. After I didn't know he repossessed it, put a new fence and everything in at the time, even after, I mean, so that was how I was paying rent.
Okay, sounds good. And Mr. Fair, you represent Ms. Miller exclusively though, correct?
No, I represent the occupants at that property, Your Honor. All occupants at that property. And the owner of the property is Miss Miller and her deceased husband. And they're
Your
occupants.
device
and-
is breaking up. I don't know if
Oh, it is?
yes.
Oh, okay, I'm sorry. Let me just go to the plan B real quick. Is that any better? If you just give me a moment, Judge, I can come in on a different device.
Okay, yes, please do.
Okay.
Sir.
It would be helpful, Judge, if I had the Zoom information. I'm looking it up now, but if the court could give that to me, I could come in. Otherwise, I'm still trying to pull up the
Okay, Ms. Nash,
Zoom information. I should have it.
could you give them the Zoom number, please?
87.
Go ahead.
876 493 1931.
See, can you hear me, Your Honor?
Yes, let's get you out of the other device.
Yeah.
Okay,
All right.
okay, can you repeat your statements?
Well, Your Honor, I'm representing the occupants at the subject property, and those occupants are Daryl Davis and his wife. The owners of the property are Betty Miller and her deceased husband, which is subject to the litigation in the Michigan Court of Appeals. So there's no question that the property is being occupied, that the plaintiff is attempting to evict the occupants, and I'm representing the occupants.
Okay, so you're not representing, so then I'm confused. You're representing Ms. Miller in a separate case and then the occupants in this eviction?
No, Judge, I'm representing Betty Miller in this case. Her husband has passed away, and the other occupants in this house, which is Daryl Davis and Daryl Davis's wife. They are occupants of the house.
Ms. Miller is not an occupant of this house.
Well, that's what she has represented to the court. But I am representing Daryl Davis, who is an occupant of the property.
Your
And
Honor,
that the plaintiff is attempting to evict.
if I may,
Mr. Turnwell, yes.
at the last hearing, Mr. Fair represented that he was representing Matthew Brown Jr. II. And Ms. Miller is not the owner of the property. Hamilton Road Limited is. by virtue of a sheriff's sale on September 29th of 2022. Ms. Miller just said she is not an occupant. You know, all along, he keeps saying he represents the occupants, and now we get different names for different occupants at different motions and different hearings.
I tend to agree. This has been very confusing, and I don't know how Ms. Miller becomes even interested party in this if she's not living in this property. And I think you knew that because that's not the address that's on this Court of Appeals filing, which was attached. It was the address of which she lives. The tenants that live here don't have any standing in the action that's before, that would have been before the circuit court. And then this is subject to a sheriff's sale. So why would they not be evicted? Did the sheriff's, you're attacking the legitimacy of the sheriff's sale and the other case?
Yeah, well, absolutely, Judge. And if we can just back up, number one, I never said that Matthew Brown was an occupant of the subject property. Matthew Brown is an individual who was working with Betty Miller in order to redeem the subject property. But having said that, and I guess I don't want to repeat myself, but maybe I need to, is the cause of action is against the occupant, and Betty Miller still owns a ownership of the property, in that issue of ownership has not been decided by the Michigan Court of Appeals. Now, Judge, I think it's important to note in this particular case that the plaintiff never had a landlord-tenant relationship with Betty Miller, never had one. It was a mortgage company that had the relationship with Betty Miller. And at the sheriff's sale, the plaintiff purchased the property at the sheriff's sale. That's fine. So what happened in the interim? In the interim, between the time of the sheriff's sale and the time that the redemption period was up, the plaintiffs in the circuit court case, which is Betty Miller, the estate of Claude Miller, Matthew Brown, and Innovative Property, were attempting to redeem the subject property. That's what they were attempting to do. And they were attempting to redeem it from the plaintiff. And
I recognize that. But my concern is that Betty Miller is not a party in this eviction because she does not reside in this property. This eviction is Hamilton Road Ltd. and all occupants, including Claude Miller. She's represented to this court. She doesn't live in this property. I think you knew that. And then you also knew that there were tenants in there that live in this property.
well, Judge, I can only tell you what my understanding was, and I don't think it makes a difference with regards to this litigation, because the plaintiff is attempting to evict the occupants, and she, Betty Miller, is still an owner, and that issue is being litigated in the Michigan Court of Appeals. So it's not like she's not an owner. That issue is being litigated. And the most important point is, if they're successful in the Michigan Court of Appeals, Betty Miller has complete ownership of the subject property. Right now, ownership is contested. And until it is resolved by a quiet title action, which is the whole point, a quiet title action, it's got to be quieted. It is still an open question as to who owns it.
I recognize that. The concern that I have is that she doesn't live in this property. She is trying to attack the validity of a foreclosure sale in efforts to redeem the property. I don't even see where I have a viable case pending in another jurisdiction. I don't see that.
Well, what you see though, Judge, is that if the plaintiff is trying to go forward with an eviction, it presupposes that, number one, he owns the property, and number two, that the ownership of the property is not contested. And as it stands right now, it is contested. It's not uncontested.
What information or documents did you provide the court to show me that there is a contested action pending in court? Because I only see what Mr. Turnwald sent me.
We have, I guess first question is there a question as to whether or not the ownership of this property is currently before the Michigan Court of Appeals?
Your Honor.
There is absolutely no issue. But having said that, what we did do is
Is that a question for Mr. Turnwall?
Okay, yes, ask.
Mr. Turnwall can respond to it.
There's a simple answer here, and it is MCR 7.108 subsection B. An appeal does not stay execution unless the appellate files a bond or the trial court grants a stay. Trial court is the circuit court. Hasn't granted a stay. They haven't even asked. No motion's been filed. The appellate court, no bond has been issued. No stay has been granted. There is nothing staying these proceedings. It's not disputed Hamilton Road purchased this property at a sheriff's sale almost a year ago. 6 months redemption period expired March 29th. It was a frivolous trial court claim being made. No one even showed up to oppose it. They only filed an answer after the hearing was already concluded. It's an entirely frivolous appeal. No attorney has signed the appeal. No attorney has signed the trial court motion. This has all been about delay. Delay.
Mr. Fair, has there been a bond posted?
In the there's been no bond in the district court, and there's
that's not what we were referencing. He was talking about for your Court of Appeals in order to get a stay. Did you request a stay from the trial court?
No, Judge, he's conflating the law here. Okay, he's completely conflating the law. Number one, you can't request a stay in the circuit court or the Michigan Court of Appeals unless a stay has been denied in the district court. He's conflating the law. So that's number one. Number two, really, quite frankly, the circuit court with regards to possession doesn't have anything to do with the district court. And then number three, Judge, you never answered your question. Your question was, is there a pending Michigan Court of Appeals case with regards to the ownership of the property? I answered that question, yes. He's got to answer that question, yes, also. But I've also attached to our answer a copy of the documents that shows that I never interrupt you. Please don't interrupt me. I have attached to our answer the copy of the filing in the Michigan Court of Appeals. But Judge, once again, he hasn't answered a question, is whether or not the case of quiet title with this property is pending in the Michigan Court of Appeals. That's really a yes or no question.
There is a case in the Court of Appeals pending. However, you have ignored the court rules. Here's another one for you. MCR 2.709. Now, this is plain English. Please answer it. Accepted the automatic stay, which doesn't apply here. An appeal does not stay the effect or enforcement of a judgment.
Judge.
We have a judgment in the circuit court. There's no appeal that stays that unless you ask for one in the trial court or in the Court of Appeals. You haven't, because they ain't gonna be granted. This is just about delay.
Yeah. Judge, he's conflating the court rules. What he is making.
Read the court rules.
Okay, we're not gonna talk over each other.
Yeah. What he is making reference to has absolutely, positively nothing to do with the district court. It is just.
It is the Court of Appeals.
No, Judge, he keeps interrupting me. I will not interrupt him.
I agree, Mr. Turnwall.
Yeah. And this is the second time he's done it, if not the third. So with regards to what he's making reference to, it's only with regards to a circuit court case and ownership and possession. That was never before the circuit court. What was before the circuit court was quiet title, not possession. Quiet title. And so there is, and they have filed their appeal with the Michigan Court of Appeals. That has nothing to do with the district court. What's before the district court is their issue of possession. And our position is real simple. This case should be stayed pending the outcome of the Michigan Court of Appeals. And why is that? Well, Judge, it's real simple. We don't want to have inconsistent determinations with regards to this property. So in other words, if the court says, well, Mr. Plaintiff, you should get possession, and the Michigan Court of Appeals says, no, you should not, no, the ownership goes to Betty Miller, then it's inconsistent results by two different courts. So it's real clear this case should be stayed pending the outcome of the Michigan Court of Appeals that is current before the court. And not to conflate the circuit court with the district court. They haven't got anything to do with each other. One is quiet title and the other is possession.
May I address this?
You may.
It's completely misrepresentation of law, facts, and reality. We're asking for possession only. Possession will have nothing to do with ownership. Possession was stayed pending the outcome of a circuit court case, which their complaint was denied. And it's not even the same parties. Today, for the first time, we've learned there's tenants occupying possession here that have possession of the premises. That was completely misrepresented by Mr. Fair last time. He said Matthew Brown Jr. II was an occupant. Obviously, he's not. We're only asking for a writ for possession. What is the use of having a trial court when the trial court enters a judgment in your favor and the district court ignores that judgment? If he wants to stay the proceedings, he needs an order from the trial court, MCR 2.109A. The court rules are quite clear. They also need to post a bond in the Court of Appeals. None of that has been done. And that's just to stay actions from the district court. We're talking about tenants occupying a premises. We're not talking about ownership. And frankly, if you want to take the opposite side, Hamilton Road Limited would be happy to take possession of the premises and then post a monthly bond pending the outcome of a frivolous appellate court proceeding.
Yeah, now we're starting to go in circles here, and we're repeating ourselves with regards to issues that have been refuted. And I don't want to keep, refuting. I don't
want to keep going back and forth either. Yeah. I do think Mr. Turnwell is conflating as it relates to this eviction. We are the trial court on this eviction. The circuit court has nothing to do with this. The circuit court only has to do with the quiet title possession issue.
Quiet title ownership, Your Honor.
I recognize, and that's not what this is. So they would not need to go to the circuit court to get a stay. They would need to come to this court to get a stay if that's what they want to do.
Yeah, and that's what we've asked for, Judge. We asked for a stay pending the outcome of the Michigan Court of Appeals case, because if they rule in our favor, and I'll say our favor, then the defendants are entitled to possession. And what the plaintiff wants to do is divest them of possession when the issue of ownership is still in question. It just doesn't really make a lot of sense.
Mr. Fair, your appearance specifically named that you represented who?
My appearance, I'd have to look at the appearance, but my appearance is Claude Miller and all occupants. And we called it Claude Miller because that is, and I have to go back and look at the complaint.
Well, I want to know who engaged you, because I do agree with Mr. Turnwell as it relates to the names that you knew who lived in this property when you appeared in our court, and you know who you represent, and you also know that Ms. Miller did not reside in this property. So this is an eviction for possession. She really doesn't have a standing as it relates to this case if we proceed for possession.
All right, Judge, so I can make the record clear. Okay. Number one, I was advising renovated property in Matthew Brown, Betty Miller, and the state of Claude Miller. I was advising them during this redemption period. And once the redemption period passed and the plaintiff refused to allow the defendants to redeem the subject property, then it degraded into this district court case. And so I was representing whoever the plaintiff was suing in the district court case. Now, clearly that does not include innovative property. Clearly it doesn't include Matthew Brown, but with regards to Betty Miller and the state of Claude Brown and Daryl Davis, well, Daryl Davis and his wife live there, but the owners is Betty Miller based upon the pleadings that were filed in the circuit court. So you can't say that, well, you know, you're not in the property, but you own the property, and therefore you don't have standing on the property that you own. It's before the Michigan Court of Appeals judge. I mean, it's just
until the Michigan Court of Appeals, because right now your claim in the circuit court was denied, and until otherwise, she's not the owner. Right now, the owner is the plaintiff on this file, which is Hamilton Road.
No, Judge, it's contested. It's contested. You can't. You can't get.
And it sounds like your Court of Appeals case is on the verge of being dismissed too.
Well, no, Judge. No, I do this. I do this type of litigation all the time. It's not on the verge of being dismissed. They sent a deficiency letter. They send deficiency letters all the time, telling you what you need to do to correct your appeal.
I recognize that.
Yeah. So it's not like the case is dismissed. And let's assume that's the case.
I didn't say that the Court of Appeals case was dismissed. So on the verge, you don't correct the deficiency, what's going to happen, Mr. Fair?
Well, if you don't correct the deficiency, it will be dismissed. It will be dismissed.
That's what I said. That's what I said.
Yeah, and Judge, and that's all I'm saying. It's not. Does not affect whether or not the case is still pending. It doesn't affect whether or not there's still an issue of ownership. It doesn't affect that the Michigan Court of Appeals can, at the end of the day, rule that Betty Miller is still the owner of the subject property. And Judge, this is not like Betty Miller didn't pay the mortgage company and that they're suing for eviction. We're talking about an individual who purchased it, and the allegations are he would not allow them to redeem it. And Judge, why wouldn't he allow them to redeem it? Because the redeeming is the redemption price, and he wants to sell the property at a windfall. He's not going to live there. He wants a windfall because of the value of the property. So, you know, when you start talking about equities, he's got unclean hands, Judge.
Okay.
I mean, just no question about it. Judge.
Thank you. Thank you, Mr. Fair. I've heard enough for today. I wanted to make sure you guys got as much out as possible. But nonetheless, I believe that the case needs to be stayed pending the ruling from the Court of Appeals. However, I am going to grant the motion for escrow as requested by Mr. Turnwall. There's no reason why anyone should live rent-free, and they're going to escrow it with the court.
Judge, may I address the issue of escrow? Well, I'm still talking, you know, Judge, the court rules say that there should be escrow. I agree that there should be escrow. The question is, how much should escrow be? And what I would like to put forth to the court is what they're requesting is $2,000. The $2,000 presupposes that they're the landlord and my clients are the tenants, and the landlord wants the lease agreement to continue at that price. That's number one. We don't have a landlord-tenant situation here. Number two, and I've attached to our brief, is that the mortgage payments by Ms. Miller was a little over $900 a month. That's it. And that is.
Mr. Fair, what do you mean we don't have a landlord-tenant situation? They were renting from Mr. Claude Miller.
No. Wait. The landlord, there's no landlord-tenant relationship between the defendants and the plaintiff.
I recognize that, but if what you're saying is correct, and that is that Mr. Miller owned the property, that I asked Mr. Davis, who did he pay his rent to? He said Claude Miller. And so I received the motion requesting a fair market value, which I think is fair, $2,000 a month for the rent. And you want us to have them escrow the mortgage amount, because the people who have indicated on this record that they live in this property were not the owners. They weren't paying the mortgage.
Well, Judge,
these people didn't have them living there for the at the price of the mortgage.
Judge, and that's fine. So I think we should ask Mr. Davis, how much is he paying rent to Betty Miller?
Doesn't sound like he's been paying anything, because I asked him.
Well, then I don't know if that's Judge. If that's the case, that's the case. But is he responding?
I can. You want me to respond?
I already asked him how much he paid. He said he didn't pay, and he hasn't been paying anything. He already told us that.
Okay, well,
Right, I was paying about $1,000 a month before that, and then Turnwald had sent me a paperwork asking for $1,600 in July to re-sign the lease with him. I didn't at the time who owned the property, and then a month later he asked me to do $2,000. So that was in the paperwork. He sent me paperwork for $1,600, and a month later asked for $2,000.
And Judge, I think that sort of sums it up right there, because the Betty Miller was paying a little under $1,000, and he was paying $1,000 and stopped because of the notice he was getting from the plaintiff. And so
okay, let me question Mr. Davis. Mr. Davis, you were paying $1,000 a month to whom?
I've been there for 12 years, to Claude Miller.
To Claude Miller, and how are you making your payments?
Sometimes cash, sometimes we call the mortgage company and directly make them, sometimes to one of their other children. But I've been there for 12 years, Your Honor.
For 12 years, you paid $1,000 and the rent didn't go up or down?
No.
And you called and paid $1,000 directly to the mortgage company?
Sometimes, yes. They gave me the access to pay that too. To MB Financial, and then it was sold to Fifth Third. I made payments to both places.
Okay. Mr. Fair?
Well, Judge, it just underscores the point I'm making. It should be no more than $1,000. But Judge, my argument is should be nominal, and let me tell you why. Because there's no relationship between the plaintiff and the defendant, other than the plaintiff purchased the property at the sheriff's sale, and he purchased it at the sheriff's sale amount, which was greatly reduced. And if you look at the interest rate for that amount of money, it would be nominal based upon how much a mortgage payment would be on the amount of money that he paid at the sheriff's sale. But I think the other point is the most important, Judge, is that no, he's not going to get the money. The money goes into escrow, and the court at some time in the future will decide what happens to the escrow amount. But Judge, if he gets his property, it's a windfall, an absolute enormous windfall. He's protected. He doesn't need any money in escrow. If he gets his property and sells it.
Somehow you got muted. I'm not sure what happened. Did you mute yourself? Mr. Fair,
I did not mute him. I did not.
I know you did it. Mr. Fair, you're muted, so we can't hear anything you're saying.
I think it should be a month.
You think it should be what?
$250 a month. And the reason
escrow an amount of $1,000 per month to be paid to the court.
Your Honor, I don't get a chance to address that.
No, I'm done. What day of the month did you pay your rent?
Oh, 15.
Okay, first payment, will be due the 15th of the month of October. You need to make that payment again to escrow to the court, okay? And the court will make a decision as to where that money will go at the conclusion of this case, or once there's a decision made at the Court of Appeals. And assuming, Mr. Fair, that your parties are successful, then this is not an issue. The money will go back to your clients. If not, we'll address that at that time. And Mr. Turnwell, did you already give me an order? I think it said 2,000 on it, though.
Your Honor, I'm not allowed to address the issue of escrow amount.
Well, you've already did. You gave a motion and you requested $2,000. You all have gone back and forth for over 30 minutes.
Mr. Fair doing the talking, Your Honor.
Well, not all the time. Not all the time. Then there was several times where you talked over him too. So then you go, then he wants to go, then that's completely, it's completely fine if you want to say something else, but then he's gonna want to say something else.
Absolutely, Judge.
So when does it come to an end? And whatever you say is not going to change my decision.
Well, that part I understand. That part I believe.
Okay.
The rest of it, no, it's just rent is based upon value. The parties, the tenants, the estate of Claude Miller are unjustly enriching themselves. Had Hamilton Road acquired possession, Hamilton Road would be renting it out either at $1,600 or $2,000 a month. Hamilton Road is being denied that opportunity. I'll address that in a new complaint. I'm not walking away from it. We'll do it.
Well,
Okay.
Judge, you got to do it. We'll see you in court on that issue.
Sounds like you will. Okay. Any additional matters for the record?
Thanks,
You know what, Judge, I do want to put one thing else on the record. You know, counsel keeps saying that this lawsuit and appeal is frivolous. Well, it's not frivolous. What he's saying is unwarranted. And if you look at the court order from the circuit court, it does not say anything about frivolous. And when you add the facts of this case, where the plaintiff was the one who wouldn't allow the defendants to redeem.
Okay.
Everything he said.
Okay. Thank you.
Not true.
Thank you. I got to move on. We got other people waiting for their
Thank you, Your
turn.
Honor.
Thank
Thanks, Your
you.
Honor. Thanks, Your Honor.
Bye. Okay, Mr. Smith.
They could be.
I don't know if you, no one showed up for you, correct?
I was in a breakout room, but I have lost track of who I even met with after watching that.
I'm sure.
I think it was-
Obviously, I have too. So
I
I'm
think
trying
it was
to.
Brenda Powell.
Miss Cowles, okay. But I don't see Miss Cowles unless she's still in the breakout room. Let me see. I don't see her. Were you all set or did you need another date?
Let's do another date. I'm going to send a reminder letter. There are some documents that are responsive to your subpoena. I'm going to work with her but I anticipate getting what I need and then calling up your staff to cancel, but let's put one out there just to be safe.
You want 30 days?
That would be fantastic. Thank you.
Can I have a date for Miss Cowles?
We can do October 18th at 8:30.
Perfect.
Okay. And for Trevino, we're going to go ahead and reset this because my understanding is that there was a call from some people and they thought their matter was going to be reset. So he may have been one of those people.
Oh, okay. That's fine. We'll look for the NTA on both cases then.
Okay, sounds good. Thank you.
All right. Have a great day. Thank you, Your Honor.
You too. Okay. Let's see, Okay, on the record, in the matter of Shores Financial versus Sierra Pitts, file number 21-01562, counsel appearance.
Morning or afternoon, Your Honor. Timothy Runyon on behalf of the plaintiff.
Okay, and then Ms. Pitts, also known as Ms. Craddock, is present today. She's filed a motion or an objection to set aside the payment order. She said she's writing to request a hearing because she was unable to make these payments due to serious reasons and would like to be able to explain herself. Did you, Mr. Runyon, have an opportunity to talk to her privately?
I have not.
Okay, let's see. And it says in your a motion to set aside a payment order, or your client's motion, which was that there was an installment payment plan that was entered back on December 20th, 2022, and she was failed to make the installment payments of $50 a month. She was $100 in arrears, I believe, at least at the time that this matter was set. So let me first see, because I don't know what her serious issues are, and I don't know if it is something she wants to unnecessarily place on the record, or if she wants to talk to you in private about it and see if you all can work through that. So let me put you in a private meeting room. Obviously, if you can't work through it, then the court will make a decision.
All right.
No problem. Let's see, room 1. Okay, I see Mary Comfort and then Erica Gillak.
Yes.
Yes, Your Honor.
Okay, today was a pre-trial. Did you all meet already?
No.
We have not.
Okay, so I'm going to put you in a private meeting room. The purpose of the pre-trial is to complete a joint pre-trial statement so that we can kick out your scheduling order. Usually we send it to the attorney's office. Ms. Gillick, did you get a copy of our standard joint pre-trial statement?
With the specific issues to discuss?
Yes, whatever. Yeah, so that you can complete that and submit that back to us once you all agree on it.
Yes.
Okay, very good. So I'll put you in a private meeting room so that you all can do that.
Okay, thank you, Your Honor.
No problem. Okay, back on the record, in the matter of Assures Financial versus Sierra Craddock. Would you able to work out a resolution on this, council?
Not exactly, Your Honor. I empathize greatly with Ms. Craddock's problems, but she hasn't made the payment. She wants to begin making them again October 1st. We have no objection to that. However, we'd like the order to be set aside upon us filing an affidavit saying we haven't received a timely payment. And she objects to that, and I'll let her address the court about it.
Ms. Craddock, can you address that?
So I'm not
for sure what honestly that meant. I just feel like due to my situation, I don't have no problem sharing it with you. I was diagnosed with cancer, had to undergo a large surgery, was on medical leave, so I was unable to pay. I had no income. I was supposed to go back to work with them thinking that my doctor was going to allow me to come back to work. They did not relieve me from that, so they fired me because I could not return to work. Shortly after that, on May 22nd, I lost my grandfather, which was like my father. Like I told him, I honestly put it in the back of my mind and I forgot about it. When I went to actually reach out, by the time I had already received the letter that they had filed to put the installments aside. So I asked him if we could start back up on October 1st. I just got back working and I will make the payments. I did, however, make payments. It wasn't like I just completely ignored the payment arrangement. I did make, I believe, 3 to 4 payments before this happened.
Okay, and thank you for explaining your position. Mr. Runyon did say that they are okay with you starting the payments. He wanted to put an affidavit. He said you wanted to file an affidavit indicating that she'd not made payments timely. Mr. Runyon?
In the event she doesn't make payments, rather than filing a motion, we thought would just be able to file an affidavit of non-compliance and have it set aside upon that, and give her 7 days to file an objection to that affidavit, and then we'd have a hearing again. But
Agreed. So it sounds like he's not objecting to you getting back on your payment. He just wants some measures in place that protects his client should you default again or not make your payments. Do you understand that?
Okay.
Okay. And so you said you're going to make, or you're able to begin making your payments again on the 1st?
Correct.
And that was $50 a month?
Yes.
Okay, I think that what's being suggested by Mr. Runyon is fair and equitable, so I'll grant that. I see here. I'm trying to see if I have an order. Mr. Runyon, when you present your affidavit, can you also provide me with an order reflecting that so that I can sign it?
Well, I wouldn't present an affidavit unless she defaults in the payment. So I will present an order to the court outlining the terms of the agreement. And
okay, I don't see an order. Let me see here. Usually there's one. With her motion, but I don't see one in here. Okay, if you can give me an order under the 7-day rule, that'll suffice.
very good.
Thank you. Do you have any questions today, Ms. Craddock?
No.
Oh, that's why she filed her motion in writing, handwriting on her own form. That's why there's no order. Okay. Okay, then we're all set, and then I'll grant you your request that you can make your first payment of $50 October 1st, and you'll make your payments of $50 per month on the 1st of each month thereafter, okay?
Okay.
Okay, you're all set. Thank you.
Thank you, Ms. Craddock. Thank you, Your Honor.
Thank you.
Thank you.
So this is Okay, the parties are coming back from the pretrial. I believe they're already scheduled for a motion for summary disposition hearing. Can we reset this pretrial to that date? And they can continue with the pretrial after I make a ruling on that hearing, on that motion. I'm bringing them back from the breakout room. A motion? Yeah, the defendant said they filed a motion for summary disposition. I think I saw it, it was really thick. And so I think it's set for the 10th, I believe, of October, but I'm not sure.
Oh, here I am. I don't know if we got.
Yes, I see it now. Yes.
Ms. Gillick, she's coming back. The plaintiff has to come back. I closed the meeting room, so even if she doesn't know how, she'll come back in just a moment.
Okay, thank you.
No problem.
Yeah, it's October 10th.
Oh, yeah, that's fine. The date is October 10th at 2 p.m. Done.
What I would do, I would set that 7:27 as a If not, then we'll set the date.
Skylark, did you catch that date? And Ms. Comfort,
I would just use that as a-
Yes,
did you hear the date?
no,
October 10th at
2 p.m.
2 p.m.
Yes. Thank you.
Okay, you're all set.
Thank you.
Thank you.